Hey, welcome to our top 10 ways to stay out of court webinar. Again, today sponsored by our partners over at the Workforce Development Board of Alameda County. My name is Anna. I'm so happy that you are all here with us this morning. Before we get into today's training, just a couple details to go over with you, especially if this is your first time training with us. So as you see, your audio is muted for today's presentation. But as you just did so wonderfully in the poll, there are going to be lots of opportunities to engage during today's training. One of the ways you might want to engage is by asking some questions. So if you do have any questions that come up, you can just put those into the chat box at any time, and we'll try to address them as we go. We may leave them to the end just so that we have kind of a concentrated question time. Or I just want to, again, remind you, if for some reason we just don't have the time or space to address that question, or maybe it's a little more personalized to your business or situation, we really do encourage you to utilize that complimentary HR hotline. You will get that information shortly. It's on the screen. And then also you'll get a PDF of the handouts that you'll have them for your reference. So those handouts will be dropped into the chat box shortly. So once you see the PDF and icon file name pop up, you can just click that and it will download locally to your drive. Again, I'll be here the whole time supporting Juliana. So if you have any issues accessing that file, just ping me in the chat and I'm more than happy to troubleshoot that with you. You saw when you logged on that this webinar is being recorded, and the team over at Alameda will be reaching out when it's available for review. So make sure you're active on their list. And then last but not least, we'll be inviting you to share your feedback at the end of today's training by participating in a very brief survey. So it's 5 questions. It takes about a minute to complete, but the feedback that you share really helps us and the team over at Alameda County make sure that we are meeting and hopefully exceeding your expectations with trainings like this. This is also how you suggest topics that you'd like to hear and learn about in the future. So we really encourage you to scan that QR code or follow that the link that I'll put into the chat for you. So again, our training today is brought to you by our partners over at Alameda County. Today, we are so happy to be joined by Darlene Hawkins, who is the Business Services Manager there, who's here to share a bit more about the resources available to employers like you. Hi, Darlene.
Thank you, Anna, and all of the CEA team for just hosting us here today. I would just want to say thank you to all of you who have joined. Please don't hesitate to share this information out. We want to make sure that these resources are available to all of our businesses within Alameda County. These are some great resources that California Employer Association has made available. We want to make sure that you're able to take advantage of them. Our team here in the Business Services of Alameda County Workforce Development Board, we want to make sure that you can contact us. Just making sure that you have all of our contact information as well in the chat. We have a team of 3, myself, Javier, and Carmelo, that are available to just help you with all of your recruitment and training needs, in addition to offering this hotline support for you in these wonderful webinars. So thank you for being here, and thank you, Anna.
Awesome. Thank you, Darlene, and your entire team for all your hard work that you do for Alameda County employers. Now I'd love to introduce our trainer today. We have Juliana Gabriel, who is our Senior HR Compliance Director. So you are in wonderful hands, and I'm going to hand it over to Juliana.
Thank you, Anna. Thank you, Darlene, and to the Alameda County Workforce Development Board for sponsoring this event today. One little reminder that I want to go over before we dive in is just that CEA is not a law firm, and we cannot give you legal advice when you're calling into the hotline or on this training today. So we are going over best practices and general guidance. But as Anna mentioned, you're more than welcome to ask questions about the content today, and we'll try to answer as many of those questions as we can. I'd also like to introduce California Employers Association, or CEA. We are an HR consulting company. We have members located throughout the state of California and beyond, and our goal is to provide you peace of mind with your HR compliance solutions. So if you do find you need some additional HR support beyond that hotline, you can join us as a CEA member, and that would give you access to our hundreds of different HR forms that we're constantly keeping up to date with all of California's changes. And we can also help you out with projects. So if you need help with a customized employee handbook, some training for your staff, or other consultation, we can help you out. We have our website listed there at employers.org, and you can also call into us directly. All right, so let's talk about what is on our agenda today. This is a very packed, fast-paced training, and we are going to just basically look at what are some of the key pitfalls in California that could end you up in court. And so we are going to look at the start to the ends of the employment relationship, as well as everything in between, including keeping your employee handbook policies up to date. We're also going to focus a lot today on wage and hour issues. These are some of the most costly issues in California. A lot of the times they can result in class actions or what's known as a PAGA case. So really important that we're getting wage and hour right in California. I'd say after wage and hour at CEA, the next big claims that we tend to see are those harassment and discrimination claims. So we're going to talk about how you can proactively address some of those potential issues before they turn into a bigger problem. All right, so let's start with top tip number 10 for the top 10 ways to stay out of court. And that is you want to ensure strong hiring practices. And at CEA, we have a phrase, it's hire slow, fire fast. So we'll talk about fire fast later in this training. But what we mean by hire slow is that you really want to be thoughtful before you go to post that job posting. What is it that you're looking for? Is it going to be an exempt or a non-exempt employee? What are the essential job functions? Do you need them part-time or full-time? If we're thoughtful about what it is we're looking for before we go to post that job, and if we have job qualifications and criteria, we're more likely to have an objective process and select the best candidate. We also want to make sure that we're compliant. A lot of out-of-state employers are surprised to learn just how many restrictions there are in the hiring process in California. So we're going to talk about some of those key ones. Another thing that we like to say at CEA is that new hire orientations really set the tone for the rest of your employment relationship. And so one thing that we recommend is developing a 30, 60, and 90-day onboarding plan with set goals to really get that person started on the right foot and to also be assessing that they are a good fit and they're adapting to your internal policies and procedures, and have that supervisor check in with them at those checkpoints at the 30, 60, 90 days to make sure they're staying on track. We also want to make sure that they're engaged, that we introduce them to their coworkers, make them feel involved. That's less likely to lead to someone who's disgruntled or maybe not the best hire when we really make them feel part of the organization. In California, we also have a lot of required hiring documents. So we have our tax documents, I-9 form, also a bunch of required notices from our state agencies. So you want to make sure you have all of the required hiring forms. All right, so what are some of those potential interview landmines that we have seen that have resulted in some lawsuits? So we want to train our hiring staff and also audit our application process to make sure that we're not asking questions about protected classifications like race, religion, gender. There's around 30 of them in California. But here's some of the ones that come up maybe a little more inadvertently or innocently. Questions about age or what year did you graduate? We want to stay away from those types of questions. Usually the interviewer is just trying to maybe connect with that person. But if that person is over 40, that's a protected class. And so if you choose not to hire them after you ask that question, they could make an argument that you discriminated against them on the basis of age. Some other ones that we see come up, questions about family status. So do you have children? Are you planning to have children? We've actually seen those types of questions lead to gender discrimination claims. And really just any classifications under most circumstances should be off limits. There's just very, very narrow exceptions to that. Some other restrictions. So in California, all employers are prohibited from asking candidates about their salary history. So we shouldn't have questions in the application about what they earned in a previous role or what their benefits package might have looked like, and we shouldn't ask those questions in an interview. We can ask questions about salary expectations. So what would you like to earn in this role, or what are you hoping to earn? That would be perfectly fine. We also have a lot of restrictions when it comes to criminal history in California. So first, if you have 5 or more employees and you go to hire someone, you cannot inquire into criminal history at all, whether it's asking questions or conducting a background check, until you've offered a conditional offer of employment. So basically, until you've selected that candidate on a conditional basis. Then you can perform that background check or ask those questions. But even if something comes up in their criminal history, you have to show that that particular history would have a direct and adverse relationship with the specific job duties. And you always have to make an individualized assessment based on factors related to that particular individual. And you also have to give them some certain notifications so that they could challenge or provide other evidence for you to consider. the Civil Rights Department has a lot of great guidance on that process in California. That could also be a question that you could call into the hotline if you need some clarification on that, because there's a lot of steps. So what we do want to focus on is questions about the job and how well they can perform it. And again, that's why we want to be thoughtful about what are the qualifications, what is it that we're looking for in this role. If you do need a packet of the hiring forms, the required forms, we do have that available in CEA store for purchase at employers.org. All right, so tip number 9 is to be aware of California's many different leaves of absence laws. So we actually have around 20 different leave laws providing for protected leave time. Now, not all of them necessarily apply to you. So there are some, actually a good number, that apply to all employers, regardless of size. And then there's some that kick in if you have 5 or more employees. That's when some of the really big ones kick in, like pregnancy disability, California Family Rights Act leave, bereavement leave. And then there's some that kick in again if you have 15 or more, 25 or more, and then 50 or more is where you can pretty much assume that all of California's leave laws apply to you. Now, all of these leave laws work a little bit differently. So some of them have length of service requirements for that employee to be eligible to take the leave. Others don't have any length of service requirements at all, and different obligations for employers. So a tip that I have is you want to have a really strong employee handbook that includes all of the applicable leaves for your business. That way you have a reference point where you can go see, okay, for this leave, how much time is it? What are the eligibility requirements? It's very difficult to memorize all of that information. And then you also make sure that your management team, your supervisors are all giving consistent information. So that would be my big tip there. So figure out which leave laws apply to you based on your head count. And one of the big ones that I'm going to go over today that applies to everyone is paid sick leave. And this one we see probably generate some of a majority of these type of leave claims. The other big ones that I see are family and medical leave claims, so CFRA or FMLA, and then also some pregnancy disability leave are kind of the big ones that I tend to see. All right, so with paid sick leave, what we're required to offer our employees in California is a minimum of 5 days or 40 hours per year, whichever is greater. That was expanded within the past few years. It used to be 24 hours or 3 days. So you're going to want to take a look at your employee handbook, make sure it is up to date on that. And your employee handbook is also a really great place to look in terms of how you offer this sick leave, because employers do have a few different options. So the default is that your employees can accrue the time. So they accrue 1 hour of paid sick leave for every 30 hours that they work for you. They're going to continue accruing that up until at least 80 hours or 10 days. So you can put that cap on that in your handbook, and it keeps carrying over up to that cap each year. So the accrual method is a little more complicated, but employees do have to work to earn that time. Then the one that's easier to administer is the lump sum or the front load method. And that is where you are just giving those hours up front, that 5 days or 40 hours. For the lump sum, it's use it or lose it. So employees may use it or not. And then it basically resets on the same day each year. So a lot of employers choose January 1 as the reset date, where everybody will reset at that 5 days or 40 hours. Now, you can require new hires to wait until 90 days to use their paid sick leave. So although it starts accruing from day 1 or it's lump sum from day 1 of employment, you can put that use restriction in your employee handbook. Paid sick leave does not need to be paid out at termination, but if you do combine it with vacation under one PTO policy, then you do have to pay out all of that PTO upon the end of employment. If you keep your sick and vacation leave policies separate, then you only have to pay out the vacation. You don't have to pay out the sick leave. So that's one of the advantages to having those policies kept separately. But if you do reinstate someone within a year of letting them go, you do have to reinstate the paid sick leave balance that they had on the books at the time they left. Also, just a really important point here, paid sick leave is very protected in California. So our labor commissioner guidance suggests that you shouldn't deny someone paid sick leave time if they don't give you a doctor's note. So we tend to not recommend requesting a medical certification for use of paid sick leave unless another leave law applies, like the California Family Rights Act, for example. And generally, we also recommend do not count absences that are taken under protected paid sick leave time against someone's attendance. Don't discipline someone for that. That could lead to a potential paid sick leave claim in California. You do also want to be aware that there are some local ordinances out there where there might be additional requirements or restrictions when it comes to paid sick leave. So some that you might be aware of in Alameda County, Berkeley, Emeryville, Oakland, they have their own paid sick leave policies. One difference for those local ordinances is you're not allowed to cap sick leave usage per year. So under the state's rules, you can cap usage per year at that 5 days or 40 hours, but that wouldn't be the case if you fall under one of those local ordinances as an example. All right, tip number 8. You want to ensure that your exempt employees are really exempt. So now we're going to spend some time on wage and hour. As I mentioned, these are some of the most costly lawsuits in California. And the reason why we want to get these classification issues correct is that if someone's not properly classified, let's say you do classify someone as exempt and they're not supposed to be exempt, they could go after minimum wage, overtime, missed meal and rest breaks, and that stacks up, per employee, per pay period. That's why it can get really expensive. And a lot of people assume that they can just pay someone a flat salary and call them exempt, but that's not the rule in California. So in California, you have to overcome the hurdles that someone has to meet both a duties test and be paid a salary minimum in order to be properly classified. So we'll go over the duties test in a minute. But for our white collar professionals, the administrative, executive, and professional exemptions, the minimum salary is $68,640 for 2025. So that's 2 times the state's minimum wage times 2080 hours a year. So every time the minimum wage goes up, that exempt salary threshold also goes up. And we cannot prorate that amount based on hours worked. So if an employee performs any work in the work week, the general rule is no matter how many hours it is, they have to be paid their full salary for that week. There also are some other exempt categories that have their own specific salary amounts. So some examples are computer professionals and physicians, as well as certain fast food and healthcare workers, just because they have their own state minimum wages that impact their exempt salary amount. So remember, the hallmark of an exempt employee is that they are paid a flat salary for the skill they bring to the job. So we can generally make deductions from PTO balances, vacation, sick leave in any increment. But for exempt employees, when it comes to making a salary deduction, reducing their salary, there's very narrow examples of when we're allowed to do that. But the benefit, if someone is properly classified, we don't have to worry about keeping track of their time, overtime, or meal and rest breaks. All right, so that's the salary minimum. Now let's talk about the duties test for those white collar exempt categories. Someone would need to fall into one of these buckets, so they don't need to meet all 3, but they need to be engaged in these types of duties more than 50% of the time. So the executive exemption is when someone's primary duty is managing 2 or more full-time employees in a business or permanent unit. And what that means is more than 50% of the time, they need to be engaged in delegating work, hiring and firing, reviewing performance, dealing with employee grievances or complaints. Those would be the type of things, truly managing more than 50% of the time. So be careful. This is where we see some employers go wrong with misclassification, is just because someone's a supervisor, they will assume that they're exempt. That's not always the case. Administrative is someone whose work directly relates to management policies or general business operations. So they have to be engaged in non-manual office tasks. Some examples of folks who would qualify: an executive assistant reporting to a sole proprietor, certain HR professionals and tax advisors, if they're really overseeing a department or management policies, and department heads would fall under that administrative exemption. And then professional, that's typically someone in a field of science or learning. So that's been interpreted by courts to mean usually a Bachelor of Science or higher that they're using, or they have a specific license or advanced degree that's outlined. So in the law, some examples that are provided are attorneys, architects, engineers, teachers. So there's a very specific list of who the licensed professionals are that would qualify. All right, so tip number 7, and I wish I had flashing lights all over this one because this is arguably one of the most important, and that is that you are following your rules for your non-exempt hourly employees. So our wage and hour rules are some of the most stringent in California, and we really have to be careful with our timekeeping practices, that we're truly paying our employees for all the time that they're working for us, that we have no off-the-clock work. So some pitfalls that I've seen is, let's say you have employees come and they're gearing up their computers or they're putting on all of this uniform and safety gear, and that's all off the clock, and then they go to clock in. I've seen a lot of plaintiffs' attorneys attack that should be on the clock time. Another issue that I've seen, if you're using paper time cards, be cautious with that. I've seen where employees are writing exact shift times every day. So 8 to 5, 8 to 5, 8 to 5, and you never see any variation with that. I've also seen plaintiffs' attorneys attack that, saying that's not realistic. That's probably not representing their actual working hours. So what I'd recommend, you can still use, paper traditional time cards, even if you don't have a punch in and punch out system. But I would at least recommend putting up digital clocks in your workplace and training employees that they should be writing the time down exactly to the minute. So if it's 7:58, write 7:58. Don't write 8 o'clock. California courts also recently have really pulled back on what they're saying is allowed in terms of rounding time. There's a Camp versus Home Depot case that I would say pretty much has gotten rid of time rounding altogether in California. I think there's a strong argument for that. We'll have to see if the California Supreme Court weighs in on that soon. But right now, we're not recommending rounding time entries. We also have to follow our rules for breaks, lunches, and overtime. I'll talk about that in a minute. And then know which wage orders cover your employees. So we all have wage orders by industry and occupation. The DIR publishes these. It's a multi-page document that basically has your wage and hour rules for your business. It is supposed to be posted in your workplace, so I would recommend printing it, putting it on like a binder ring and hanging it up next to your all-in-one labor law poster. So put that on your to-do list. I've heard recently with agencies auditing and saying, hey, you don't have your wage order up in your workplace. So make sure you put that on your list. All right, so starting with minimum wage, our state minimum wage right now is sitting at $16.50 an hour. But in California now, we do have some industry statewide specific wages. Fast food for chains with over 60 locations nationally is an example. They have $20 an hour. And then healthcare facilities also now have their own local minimum wage requirements, ranging anywhere from $18.63 to $24 an hour, depending on the type of facility. In California, we're going to make it a little more complex. We also have over 40 different local ordinances that may apply. This is really important. So the local minimum wage is based on where your employee is physically performing the work. So if you have remote employees that are in a different city or county, you're always going to want to check that. Or if you're sending employees to different client sites or conferences for the day, we always have to check on those local minimum wages. So while Alameda County follows the state minimum wage, a lot of the cities within Alameda County have their own. And a lot of them went up recently on July 1. So just to give you some examples, the city of Alameda went to $17.46, Berkeley to $19.18, Emeryville to $19.90. So those are some examples. We do have this bit.ly link here where you can access all of the current local and state minimum wage requirements. And I noticed that Anna also did just put that link in the chat as well, so you can access it there. All right, so let's talk about rest breaks in California. What is required for our non-exempt hourly workers? So an employer is required to authorize and permit an employee to take 10 minutes net rest time for every 4 hours worked or major fraction thereof is how the law reads. So once someone hits 3.5 hours, you can see in our chart here, they're going to be owed at least one rest break. If you're looking at a typical 8-hour shift, we're going to have 2 rest breaks, and as we're going to learn in a minute, 1 meal break. Meal and rest breaks are so heavily litigated in California. It's important that you have a really strong process and really good documentation on it. A rest period needs to be in the middle of a work period. So you can't put it at the beginning of the day so that someone can come in late. You can't tack it on to the meal period. It needs to be in the middle. But we otherwise don't have strict timing requirements on the rest periods. Rest periods are paid time. So typically someone is not clocking in and out for that. So what I would do is I would highly recommend that you do have some documentation in your payroll system or on your time cards where employees can certify that they've received all required rest periods and that they understand if they don't receive the required rest periods that they need to notify their supervisor or HR about that. I've seen that be used as a defense in lawsuits when someone's claiming a bunch of premium pay penalties for missed rest breaks, where the employer can point to, you certified every single time card that you did receive your rest periods. You never put us on notice of this. So it harms their credibility. And then remember, we cannot restrict employees from leaving the premises. So this is completely their personal time. We shouldn't be interrupting them with any sort of work questions, right? And if we fail to provide a sufficient rest break for our employees, we are going to owe 1 hour of premium pay at the regular rate of pay for that employee. If it was the employee that just voluntarily chose to miss that rest break, make sure you get documentation on that so you can prove that it was their choice. And also, I would not allow that to become a practice. So make sure that you're coaching them, disciplining them as needed to take all of their meal and rest breaks. All right, so for the meal break, we need to permit a minimum 30-minute uninterrupted meal break if an employee works more than 5 hours in a workday. So it's going to be triggered once they go over 5 hours, we have that first meal period. Once they go over 10, we have the second meal period that kicks in. Now, it's a little bit different than the rest break. This time is unpaid, so they are clocking in and out, and we should see sufficient records of a full 30 minutes. If it's 29 minutes, 28 minutes, arguably premium pay should be paid in that case. So it needs to be the full 30 minutes. If it's due to the employee, again, it was their voluntary choice to come back early or not take their meal break. Make sure you get documentation on that. If you don't have strong documentation, courts have been made it very clear that it will be presumed against the employer that you did owe that premium pay penalty. So make sure that you do that. The meal break does have strict timing requirements. So it needs to start before the end of the 5th hour of work, which basically just means they should be clocking out to begin that meal break no later than 4 hours and 59 minutes into their shift. So again, I would recommend here that you're scheduling the meal breaks for the 4-hour mark or 4-hour and 30-minute mark, just in case someone gets tied up with work. You're not going to potentially run into that premium pay issue, that you have a nice big buffer to make sure that that person still goes to their meal break on time. And again, no time clock rounding of meal breaks. California courts have been very clear on that. So you can't say, well, it was a 29-minute meal break, we're just going to round up to 30. Not allowed to do that. It needs to be a full 30 minutes or more. So you want very clear records on that. All right, now let's talk about overtime in California. We have a lot of requirements in California. So under the federal law, FLSA, you're only looking at that weekly overtime of over 40 hours in a work week. But in California, we have daily overtime, we have double time in certain cases, and we have a special rule for the 7th consecutive day worked in the work week. So I'm going to unpack these rules. This is what is applicable to most employers, but you're always going to want to check your IWC wage order. That's where your particular rules would be. There are occasionally some exceptions. But for most employers, this is what's going to be required. You need to pay time and a half, someone's regular rate of pay, if they work over 8 hours in a workday, that's the daily overtime, over 40 hours in a work week, that's weekly overtime, and then on a 7th consecutive day worked in the work week, the first 8 hours is all at time and a half. Really important how you define your work week. So if you define it as the default of Sunday through Saturday, it's always going to be a 7-day period. Then you'd always be checking that Saturday to see if they worked all of the days in the week and does that Saturday need to be at overtime. But if it's Monday through Sunday, you might choose to define your work week differently. If it's Monday through Sunday, then you'd always be checking that Sunday. So make sure you check your handbook on that and make sure it's in alignment with how overtime is being paid in your system. And then we need to pay 2 times the regular rate of pay if someone goes over 12 hours in a workday, and if they work more than 8 hours on that 7th consecutive day, it kicks into double time. Now, here's a really important point. This gets litigated a ton in California, I think, just because it's so complicated. But overtime pay is based on the regular rate of pay, not the base hourly rate. So let me kind of just give you an example of that. You might have a base hourly rate of $16.50 an hour, but if your employee earns additional compensation, let's say they earn commission, piece rate pay, non-discretionary bonuses, that all gets factored into the regular rate of pay. So let's say they do earn commissions in that work week and it's factored in the regular rate of pay. And when you factor in the commissions, the per hour value of those commissions, it's not just $16.50 an hour. Their regular rate would maybe be $18 an hour when you factor in the per hour value of those commissions. Well, it's that higher value, that regular rate of pay, that needs to be used to calculate overtime. Regular rate of pay is also used for paid sick leave, premium pay penalties for meal and rest breaks that we just talked about, reporting time pay. So it comes up in other contexts. And if we're not doing those calculations properly, or our payroll system isn't accounting for those additional forms of compensation, you're looking at potential penalties and liability exposure for that. And again, that can stack up really quickly, right? Per employee, per pay period, separate violation for the wage statement being inaccurate, doesn't accurately reflect overtime. So this is something that we want to audit and make sure we're getting right. All right, and I also want to cover the PAGA reform that happened last year. So for those of you who are not familiar, PAGA stands for the Private Attorneys General Act. And this law, what it does is it allows employees to basically step into the shoes of the California Labor Commissioner and go after penalties after their employer for wage and hour violations on behalf of themselves and also other employees. So they're similar to class actions, but they're a little bit different from a class action lawsuit. And those penalties are on top of whatever the employer already owes for the underlying violation. So they can just stack up and get very expensive. So there's been a lot of criticism that PAGA has harmed a lot of employers that are trying to do the right thing, and they get hit with these lawsuits. And then it's, arguably a lot of the times the plaintiff's attorneys who are really benefiting from PAGA. And so there was some reform, and they made PAGA a little more employer friendly. A lot of it's really more relevant for attorneys who are litigating these cases. But there is one thing I want to call your attention to that changed last year. And what it is there are now new opportunities for employers to reduce their penalties if they're hit with a PAGA lawsuit, sometimes by up to 85%. So if you think about it, that's a big amount, right? 85% of the penalties you could potentially avoid if you can show that you're taking reasonable steps to comply with wage and hour laws. And the legislature actually spelled out what the reasonable steps are that they want you to be taking. So they say you should be conducting periodic payroll audits and taking action in response to results. So taking a look at your meal and rest break practices. Are we paying premium pay when we need to? Is overtime being calculated properly and the regular rate of pay? Do we have all required information on our wage statements, right? We want to be looking at all of those types of issues and correcting them when we find deficiencies. The other thing they want to see employers doing is distributing lawful written wage and hour policies. So here I would recommend that you are distributing your policies on timekeeping, overtime, meal and rest break rules. Have your employees acknowledge those policies. I'd recommend at least on an annual basis to show that you're doing that. Training supervisors on wage and hour rules. So they didn't go so far as to mandate training, like we have mandated harassment prevention training, but now employers have a really big incentive to provide some level of formal wage and hour training for your supervisors. And then finally, taking corrective action for supervisors who are not following your policy. So if you have supervisors, for example, that are interrupting people during their meal breaks with work-related questions, we would want to follow up with them on that, coach them, discipline them as necessary, and retain those records. We do have a wage and hour audit package with a comprehensive checklist to help you through your own audit. And it also comes with a recorded training for your supervisors that's about 30 minutes long. So if you would like that additional resource, it is available for purchase at employers.org. All right, tip number 6, and I promise you this is my last wage and hour top tip that we're going to cover today, and that is avoid misclassification of independent contractors. So here, same thing. If we misclassify an independent contractor, we're looking at those potential wage and hour penalties, right? Minimum wage, meal and rest breaks, overtime, just like with our misclassification of exempt employees. And California makes it pretty challenging to classify someone as an independent contractor. Some would argue almost impossible. So this is the rule. A person providing labor or services for pay shall be considered an employee rather than an independent contractor unless the hiring entity demonstrates that all of the following conditions are satisfied. So that person needs to be free from control and direction of the hirer, meaning they're really choosing when to perform the work, how they perform the work. You're not micromanaging that since they're an independent contractor. Think about when you hire a plumber to come fix a leak. Are you standing over their shoulder telling them how to do their job? No, right? Because they're an independent contractor. They need to be performing work that is outside the usual course of the hiring entity's business. This is the prong where most people fail the test. So for example, we're an HR consulting company. If we hire someone as an administrative assistant that's helping us with outface with our members and helping with taking calls, arguably that's within the course of providing HR services, right? It's within the course of our business. So we probably should not be classifying that person as an independent contractor. Of course, there's a lot of gray area in between, right? These rules are not black and white, which can make it challenging. And then someone needs to be customarily engaged in a trade, occupation, or business of the same nature as the work that they're performing for you. So basically, they are holding themselves out to other clients. It doesn't look like it's a sole employment relationship. So we recommend in California, before you classify someone as an independent contractor, we'd highly recommend you consult legal counsel. Even if they're properly classified, it's still a really good idea to have that contractual agreement with them in writing. In some cases, you're required to do that. So always a good idea to get some advice on that. All right, tip number 5 is insure your business. So there's some insurance that we're required to have in California, and then there's also some insurance that we really recommend having. And this is because we can't avoid bad things from happening in our workplace or getting sued. Sometimes they're frivolous lawsuits, but it takes time and money to defend them, even if we're doing everything right. We've had a lot of employers call in over the years that they've been in that situation where they felt they've done everything right and they were still hit with a lawsuit. So sometimes we just can't prevent that from happening. Now, let's start with what we do need to have, what we're required to have, workers' compensation insurance. So this is viewed as basically a mandatory bargain between employers and employees, where if an employee gets injured in the course of their job or becomes ill as a result of their job, then they can't go directly after the employer for that. So that's a good protection for the employer. It would have to go through the workers' compensation insurance process under most circumstances. And so it protects the employer, insulates the employer in that way. But also for the employee, if they go after an employer that doesn't have the funds to cover that, again, that workers' compensation insurance ensures that that person can get medical care taken care of, wages, etc. So really important that you know your carrier, that you have open communication with them when you are dealing with those employee injuries, and that you understand the workers' compensation process. So anytime someone gets injured and it goes beyond what's known as beyond first aid care, we have to start that process by giving the individual the workers' compensation claim form so that they can file a claim if they would like to do so. So be aware of that. Even if it's a smaller injury, we should still be documenting that. So we should let our employees know, make sure we train them that even if it seems like a minor injury, we still need to keep and maintain records for that. And then have that open communication with your carrier when you are dealing with those workers' compensation claims. The more information you give them, usually the better position that it's going to put you in. And then in terms of what you should really highly consider, employment practices liability insurance. So this provides protection. It can really be whether it's a current employee that's going after you, a former employee, or an applicant suing you, let's say for discrimination. That's when your employment practices liability could kick in. And you're going to want to see, if you do have it, what types of claims it covers. So it can vary, but some examples are it could cover discrimination, harassment, wrongful termination. wage and hour claims in certain cases. And so that can just help you sleep a little bit better at night, knowing that if you do get a claim, here's the potential exposure of what we could be looking at, or this is how much coverage that we have. All right, step number 4 is we want to prevent and promptly correct harassment. So as I mentioned, I'd say right there after wage and hour, the next biggest claims are some of the most expensive ones that we have seen over the years is those harassment and discrimination claims. And so number 1, we want to make sure that we're doing everything that we have to do or that we're supposed to be doing. And so if you have 5 or more employees, make sure you're keeping up to date on your mandatory harassment prevention training. So that's due every 2 years. Employees need to get 1 hour, supervisors and above need to get 2 hours of training. And then for new hires, it's typically due within 6 months of hire. So keep up on that. While there's no necessarily direct penalty for not doing mandatory harassment prevention training, we have seen this used against the employer in lawsuits where you have someone that, harasses someone and then the plaintiff's attorney starts looking into, well, when was the last time that person received harassment prevention training? And then it's a really bad look if that employer is not within compliance. Also, when we do get complaints of alleged harassment, discrimination, retaliation, we need to take those very seriously, and we need to make sure that we have a response to those types of complaints. So the standard under the law is anytime the employer knew or should have known of an allegation of harassment, discrimination, or retaliation, they need to investigate that and then take prompt corrective action as needed. So that's required under our California Fair Employment and Housing Act. And that new or should have known standard is triggered by any supervisor being aware of it. So our supervisors have to understand that once they learn about something, if someone comes and complains to them or vents to them, they need to escalate that up to management or HR so that we can investigate it. That should be covered in mandatory harassment prevention training, but it's not a bad idea to reiterate that to your supervisors. And then here, just kind of moving away from compliance, but just a really practical tip is make sure you're also encouraging a communication culture in your workplace. What we mean by that is make sure that people feel comfortable coming to HR or their supervisor. They feel like they're heard, that they can trust HR, because the more that you know, it gives you an opportunity to try to resolve that, or at least have that person feel like they're being heard and they're taken seriously. When we tend to see employees go and hire an attorney or go and make a complaint with the Civil Rights Department or EEOC is when they feel they're not being taken seriously, when they're not heard, or that they have no avenue for that, right? And so that's really going to start with leadership. That really comes from the top. And if there has been a kind of a culture of distrust or skepticism, you have to work on really rebuilding that with your employees. And then, of course, make sure your policy is really clear on how they bring a complaint forward, confidentiality, how that works. We cannot promise complete confidentiality because, like we mentioned, supervisors have an obligation to escalate it, right, to management, or we might have to talk to witnesses about what happened, but we will keep it as confidential as possible, is what you can tell the employee and also include in your policy. And then we have to make sure that we have a timely response. So some potential investigation triggers. It could be that someone brings a formal complaint to you, but it could happen more informally. Maybe they just say, I just want to vent. I don't want to bring a complaint. It's not really up to the employee. Once you meet that new or should have known standard, you are going to have to proceed with investigating that and engaging in prompt corrective action. Sometimes nobody complains, but maybe you observe the conduct or overhear conduct that seems inappropriate. You're going to have to investigate and look into that. Other ways that it could come up, gossip and rumors, unexplained changes in workplace behavior, attendance, morale. Those are all things that should be explored as part of that communication culture. And then especially when there is a true allegation of harassment, discrimination, etc., we're going to want to investigate that promptly. All right, tip number 3, we want to make sure we're using effective discipline and documentation. Now, I hear all the time from employers that, they'll call in and they'll have an employee that maybe they're wanting to terminate. We'll talk about, what level of documentation do you have for this person? And they'll say, well, we don't really have much of anything. You know, it's hard to stay up on that with all of the day-to-day business. And we do want to make sure that we are staying up on that documentation, because we want to have that record of what's happened with that employee. Because even if they're at will and we're allowed to terminate them for any lawful reason, they might claim that it was for an unlawful reason, right? And if we don't have documentation to support what went into making that decision, that might place us in a harder position, or it may make it more likely that we end up with that wrongful termination claim. So it is very important. Generally, what we want to have in that documentation is state what the problem is very clearly. So be very specific. We don't want kind of broad words like, this employee's been lazy or they're slacking. Give specific examples of what they're doing. The employee missed this report, they missed this deadline on this day, right? And then detail the consequences. So let them know that if there's additional issues, it can lead to disciplinary action up to and including termination. If we have to put them on a performance improvement plan, if we're kind of getting near the end of the road with that employee where we feel like we need to give them kind of a last chance, make sure that that's very clear. You can also list ways that you can help them, or if other resources that they can get to maybe get trained up, right? And then get their acknowledgement, get their signature, so that it's clear that you have discussed this issue with the employee, you're trying to work on it with them. All right, so we've made it to tip number 2, and that is fire fast with no surprises. So I started this off with hire slow, fire fast. So what do we mean by fire fast? So we don't mean to rush the termination process. And certainly if you don't feel like you have your ducks in a row and you're not ready, that's not what we're referring to. But what we mean is once you have made that decision to end employment, move swiftly on that. We have seen situations where someone's getting ready to terminate, and then that person maybe files a harassment complaint, or they request a protected leave of absence. And guess what? That's now probably going to look like retaliation. Even if that's not your intent, it could look like on paper retaliation, especially if we don't have a lot of good documentation on what's been going on with this employee. So we do generally recommend to move swiftly. Also, while you're delivering that termination news, make the process quick and fair. So we don't need to go over everything this employee's ever done wrong, right? We've reached the end of the road now, but we also want to be fair and do it with dignity. There's a lot of the time we hear that employees that feel that, and there's statistics supporting it, employees that feel that they weren't handled with respect or dignity in that termination process are much more likely to go and file a lawsuit. So even if they've been very difficult, maybe you don't particularly care for the person, keep it very professional. And then we like to say there really should be no surprises. If you've been documenting performance issues or policy violations, it really should not come as a huge surprise to this person. The one exception, of course, would be if it's a layoff situation or budgetary reasons. Sometimes that comes as a surprise, but most of the time it really shouldn't. Or it's a very serious violation, right? You found out they've sexually harassed someone or they've committed fraud. That also shouldn't be a surprise, right? Because that's a very serious violation, even if you don't have a ton of history with that person. Biggest important thing, or one of the most important things at the time of termination, is to make sure that you timely provide that final paycheck. Because if you don't in California, that can result in waiting time penalties for every day that that paycheck is late or deficient, which is a day's worth of wages up to 30 calendar days. So that can get expensive. So if someone is resigning and they give you more than 72 hours notice, then pay is due on the last day. If they are quitting with less than 72 hours notice, maybe they just quit on the spot, you have 72 clock hours after notice is given to produce that final paycheck. So that's not business hours, that's clock hours. Now, one thing that could help is you can mail the final paycheck if it's a resignation. If the employee requests payment by mail in writing and they provide you the mailing address, and then the date of mailing is considered the date of payment. So that kind of can buy you a little bit of time in that situation. And then for an involuntary termination, anytime you're ending the relationship for whatever reason, pay is always due on that last day of employment. And we recommend when the words are leaving your mouth. We've heard some horror stories where employers have terminated someone, they didn't have the final paycheck, they were going to cut it, the person left the building, and then claimed waiting time penalties. So when the words leave your mouth, that's our recommendation. And then final pay should always be a live check. So our labor commissioner interprets that any direct deposit agreement does not apply to that final check. You'd have to get a separate agreement for the final check purposes. So it should be a live check. Even if you do get an agreement for that final check to direct deposit it, it still has to be on time. So for an involuntary termination, still has to be run on that last day of employment. All right, so some best practices in that termination meeting: have a witness present so they can attest to, what was discussed, what was provided. If it is a voluntary resignation situation, make sure you get documentation from the employee on that, if you can, to indicate that it was voluntary. Their selected date, right, can show what their date was, and then also usually would like to get the reason why for your records. We generally recommend conducting an exit interview. That's usually a matter of discretion based on the circumstances, whether you think that's appropriate. But again, with that open communication culture, it can sometimes give us insight into what might be going on with other employees and the reason that they left. And then use a termination checklist signed off by both parties, stating what each party has received, what's owed. So if they do owe you their keys or their laptop, for example, and then the required notices. So if you do need that final termination paperwork, we do have that available on CEA Store through employers.org. Luckily, the required paperwork at the time you're ending employment is a lot less than what you need at the time of onboarding. At onboarding, we have a long laundry list. All right, we've made it to tip number 1, and that is follow and keep your employee handbook updated. So our employee handbook, what is it used for? It's really important to overall just set a positive professional tone for your business. It shows that you have it together, right? You've considered these policies. It sets expectations for your employees on the one hand, and then on the other hand, for your management team, your supervisors, it ensures that uniformity and consistency. Also, we do have some required policies that I'm going to talk about in a minute that we have to have in California. So we want to include those in our handbook. It can help be your defense. Like we said, if you have that complaint process in there, if you get a harassment allegation, and then we want confirmation that employment is at will when that applies. We always want to be very clear about that. Now, I do know that you can get CEA's template through Alameda County Workforce Development Board. So that is a benefit that they provide to all Alameda County employers for our handbook template. So please reach out to them if that is something that you need. All right, so let's go over the required policies. At will is technically not required, but it's so important that we put it on the required list. You want to reiterate that. Harassment prevention, you need to have lactation accommodation. So that is in regards to pumping rights at work. If you have 50 or more employees, you need to have an FMLA policy. 5 or more, you should have a California Family Rights Act leave policy, pregnancy disability leave, and then paid sick leave really should be in your employee handbook, and be really clear about which type of paid sick leave you offer. Is it on an accrual basis or a lump sum? And then other really important ones, policies on timekeeping, meal and rest breaks, overtime. We talked about that, right? That the legislature wants to see that employers are distributing up-to-date wage and hour policies. I mentioned I would have all of your applicable leaves, even the ones you're not required to have under law, but that apply to you, I would have in your employee handbook. So you have that as a reference. Vacation, attendance, drug and alcohol-free workplace, conduct, those are all super important ones as well. All right, so we've reached the end here. I do want to see if we have any outstanding questions I can answer before we go. And if we didn't get to one of your questions, please take advantage of the hotline. You can call into us. I have the number up here on the screen, and you can reach us Monday through Friday from 8 to 5. So Anna, I want to check with you if we have any outstanding questions before we close out here.
I believe you may have spoken to it. I didn't hear an explicit, but I just want to make sure in case Kathy didn't get that information. She did ask, what will minimum wage increase to in 2026 for regular employers, with 25 plus employees. Do we have that
So, yeah, so I don't know if she's referring to on a local level, because local minimum wages do go up on January 1. So that could vary by city. And then I haven't heard an announcement yet on a state level, but usually in the fall time is when we start to get answers for that. So stay tuned. You can also call the hotline for updates.
Perfect. So I am dropping the next training into the chat. This is a very timely topic. So if this is something that you're interested in, I just put that link into the chat. It's what to do when ICE shows up at your California business. This is coming up on, let's see, August 28th. Again, this is complimentary from our partners over at Alameda County. I did just see, let's see, a couple of questions. Juliana, do we have, I know we have like barely a minute, but did you have a moment, or should we just direct our friends to the HR hotline?
I see one that came in. I'm happy to answer it real
Okay,
quick.
I have one in the chat and then one in the Q&A, so you can choose your adventure. One's about fast food, and one is about disciplinary action.
All right, I'll speed talk here. So what happens if an employee refuses to sign a disciplinary action form? So that's actually pretty simple. You can just have a witness note that that person has refused to sign. So you can just say employee refused to sign, and then sign and date the form yourself. And we would still recommend providing a copy to the employee for their records, and then one for the personnel file. And then one in the chat. Would you mind reading that one for me, Anna? Are they? Oh, I see it.
I was just asking Catherine to call the HR hotline just in case we couldn't get to it. But it's are they expanding the fast food to coffee shops and cafes in 2026, or did that occur this year? And if it did, can you send a specific link?
Yes, so it could apply if they are considered fast food and they're part of a chain with over 60 locations nationally. So it could be, they do list this in the DIR FAQs, like something like a cafe or a donut shop. So that could already apply, but it just depends on if you're a part of a chain. And yes, if you want to reach out to us and call into the hotline, we can get you a link to those frequently asked questions with the DIR.
Love it. Yes, I did provide the PowerPoint slide deck a couple times. However, I know if you are joining from a mobile device, like a phone or like a tablet, sometimes that's where Zoom does not like to pass on that PDF. So if that is the case, what I'll just do in general is I'll pull the registration list and I'll make sure everybody gets a copy of that PDF. If you can just give me to end of day, I'm more than happy to send everyone that PDF, just to make sure everyone has it, because I know this was a lot of information, and Juliana does such a great job of paring it all down for us, but I know it's still a lot. So with that, let me get you the codes. I know those are on the screen, but I always like to put them in the chat just in case. So your HRCI and SHRM codes today, in case you're joining us for continuing education credits, your HRCI code 712543, SHRM code 25-5NP67. Please email ceainfo@employers.org or reach out to that Alameda HR hotline if you are eligible for certification and you don't know what to do with those codes or run into some trouble. We're more than happy to help you. So yeah, thank you to the team over at Alameda for everything that you do for employers. Thank you, Juliana, for sharing your time and expertise. Thank you all for sharing your morning with us. And I do want to encourage you, I did put the link into the chat a moment ago. You can also scan the QR code that's on your screen right now, but this is also how you suggest future topics that you'd like to hear. If there's something more that we can do to bring you peace of mind, please let us know. Anything else you'd like to share, Darlene? Any upcoming events that our employers need to know about?
Thank you, Anna and Juliana. We just look forward to you joining us in our next webinar, and do connect with us on our website. We have many events. We're happy to work with you and see how we can support your recruiting and training needs. Thank you.
Perfect. Well said. And again, thank you for your partnership and all that you do. And we will see you all on August 28th for that next training. And we'll see you then. Enjoy your day, everyone.
Thank you.